Okay, well, here we are again for another short video lecture on business organizations. I'm Rob Dawalt, and I've got my alternative email up here, robdawalt@me.com. Remember that you can also always check out your syllabus for other information, phone number, and school email if you need to contact me, so you have three options there. We're going to talk a little bit about general partnerships today, so I hope things are going well. If you remember, we've talked more specifically on just general subjects about business, and then on proprietorships, sole proprietorships. Remember that we discussed the fact that there's substantial percentage, probably 80%, are very small businesses in the United States. So it's in the interests of business to try to keep things simple and streamlined for people. But the other problem that we get into is this is a complex society, and more we are requiring that there be written agreements on different things just for everybody's protection. Where this brings back to is the statute of frauds, which is out of contracts. And basically what the statute of frauds says, any transaction for real estate or over $500, or if it's a lease that lasts more than 1 year, it has to be in writing. Well, partnerships can still be oral. You can still have handshake partnerships. That is again in line with the basic attitude in this country to try to keep things simple and allow these small businesses to survive. That being said, with the onset of these issues that we're seeing about health care, Social Security, unemployment, there are more and more requirements on small businesses. And if you think of a small business like a family farm, think about the requirements nowadays for handling chemicals like fertilizer and stuff on your farm. You have to be certified, you have to go through a school, you have to get approval. And so everything we do in our society has become much more complex, and with good reason, because of the methamphetamine. People are using farm chemicals to build bombs for domestic terrorism. There's just a lot of reasons why we have to put controls on things and require training and written requirements in order to make things work in our society, because you need a paper trail on a lot of different things. So with that being said, keep in mind that the general thought is to try to maintain a streamlined, simple structure, but there are some requirements that are coming up more and more for some degree of a written document. Now, like I said, that being said, general partnerships can still be strictly oral, or they can be even implied. And when we say implied, what that means is if everybody acts like something is a partnership, then it is a partnership. And that's what we call an implied partnership. And what a partnership is in the first place, a definition would be a voluntary association of two or more persons who agree to carry on business together for profit. And so the issue there is several points. Voluntary association of two or more people. So a sole proprietorship is out. That's what differentiates it from a sole proprietorship. Also, it's a business arrangement. And then finally, it's for profit. It's not a not-for-profit. That has a separate way of defining itself. Think of this, though: unlimited personal liability, business debt, any kind of liability for slip and fall outside the business. You send a truck driver off somewhere to deliver goods, he's in a car wreck, then all the partners are personally liable. And what that means is they can dip into all your assets, whether you got them from this business or you inherit them from your dad or wherever you get them. So that's a big disadvantage of partnerships, is because there is unlimited personal liability. And so, you know, I don't think most people really understand that it goes far beyond the assets of the partnership, but also into your personal family assets. There is a move toward more organization and more complex organization, and there's a couple things. There's called the UPA, Uniform Partnership Act, and it is a model act that a number of states have gone together and created, where they meet in a kind of a formal setting among all the 50 states. They're all invited to send representatives like the Attorney General to discuss, you know, trying to have Uniform Partnership Act so that it could go across state lines, so that if someone wants to run a grocery store in Indiana and Ohio, for example, then you would have one set of rules to follow. This is only caught on in about 1/4 of the states, so 50 divided by 4, you know, what does that work out to be? And so, you know, you're looking at some number between 10 and 15, and so, you know, in other words, it's not a big percentage. 25% have adopted what's called the UPA. Now there's a new one called the RUPA, which is the Revised Uniform Partnership Act, and it's a model of partnership legislation from another meeting held by the same group later to develop, you know, they saw the UPA, they worked with it for a while, and they thought, well, you know, this is good, but there's some changes that we need to make to this UPA, so they call it the RUPA, or RUPA, and it's the Revised Uniform Partnership Act, and it has been adopted generally in most of the 3/4 of the other states. So there's actually 3 models out there. There's a catch-all model, which people do their own little unique thing in some oddball states. Indiana is usually one of them that does some weird thing. Then there's a number of other states that are divided into 2 groups, either the UPA, which is 1/4 of the states, or the RUPA, which is 3/4 of the states. And so keep in mind that partnerships break down, as of about 2008, partnerships break down into a number of different areas of interest. The arts, for example, recreation, entertainment, 2%, healthcare, 2%, agriculture, fishing, forestry, 5%, food services, 4%, retail trade, which is like haberdashery, women's clothing, that is 5%. Construction businesses, where a couple guys say, well, let's get together, I know how to put on siding, you know how to put on windows, so let's form a little construction company and remodel houses. That's 6%. Financing and insurance is one of the bigger ones, 11% in you know, investment, counseling, and insurance. Waste management is 2%. Professional and scientific and technical services, these could be expert witnesses, that makes up 6%. One of the biggest business entities of partnerships in the United States is anything related to real estate. That can be sales, rentals, leasing, anything like that. That's 46% of all partnerships in the United States are involved somehow in real estate. So you can see that there's a strong interest between the business class and the property class. Like I mentioned earlier over in property, I said, you know, there's a lot of these things that are interrelated. So there's a catch-all one called other, which is 11%. So just in your little thinking cap, put, you know, like 50% of all partnerships involve real estate in some way. Some of the advantages of general partnerships is they're easy to form. You just get together. You can do it on a bar napkin. You can just shake hands. You can say we're partners. Can be very flexible. You can divide the business, like I said. Let's say that someone's in construction. Someone wants to do windows. Another one wants to do siding. Another one wants to do roofing. So you can divide up people based on their strengths. In real estate, you may have somebody that says, I want to do commercial real estate. Well, that's fine. I'll do the residential real estate. So you see what I'm saying. Now, one of the things is that the depreciation and the losses for tax purposes can be passed through from the business to the owner. So that's a big advantage because you can take a lot of this off of your taxes. The other thing about it, though, is if you're very successful, you have to pay taxes on it too. So it can be a plus or a minus, but generally speaking, with the depreciation, some of those capital gains and things like that, there are certain advantages for tax purposes to be in a partnership instead of a corporation. The big disadvantage of general partnerships is the unlimited personal liability that I mentioned. There's issues with continuity. Someone wants to take off on a vacation and they're in charge of windows and you're in charge of siding and you don't know anything about windows and somebody calls in with a question about windows. What do you tell them? You don't know what to tell them, so you're not working on that case. It's a little bit different. It's difficult to transfer. You want to sell out, who are you going to sell it to? The windows guy is going to want a guy to be a siding guy, so it narrows down who can be the partner, and you don't necessarily trust Joe Smirts that walks in off the street. It's got to be somebody that you trust. So it's can be tough to sell your interest and retire. You're almost married to the business. Well, this is important. If you do have any kind of a written agreement, it needs to be formalized with certain elements. And so these elements include the name of the partnership. You have to have some kind of a name, obviously. Is it Jones and Smith or Smith and Jones? Or if you just want to totally get away from that, Reliable Construction. So something like that. Names and addresses of the partners. Recitals. This is what are you guys going to be doing? What's your business going to be about? What's the purpose? What's the address you're going to operate out of? Where does your mail come from? Who should you serve papers on? What are the terms? Is this forever? Is it for 10 years? What is it about as far as how long is this partnership going to exist? What are the financial? Is it a 50-50 split down the middle? Or is someone else putting up more money so they want 60-40? How are we going to handle the profits? Are we just splitting them down the middle, or are we going to split the profits and losses 60-40? Who's in charge of what? Who's going to run the office? Who's going to work out in the field? And who's going to do the residential real estate? Who's going to do the commercial real estate? How would you handle if you wanted to add, you want to expand and you want to add another partner? Well, you ought to think about that and put that in your partnership agreement. If you want to add partners, does it have to be 100% agreement of both parties or what? How do you dissolve this partnership? How do you break up? How's it going to be handled? I mean, there's going to be money in the bank. There's going to be debts to pay. How are you going to split this up at the end? And there's any kind of miscellaneous provisions that you want to add. Could be about retirement. It could be key man insurance. Number of different things like that. Signature and dates. Of course, you want to put your signature on there and the date, and probably even print your name under your signature. So those are important considerations. Now, one thing to understand is, like I just touched on, is dissolution. And under the UPA, which is the Uniform Partnership Agreement, there's like a wrapping up of the business affairs. And so, basically some things can happen. Basically, you could just have a certain term, like 10 years for this partnership. 10 years has passed, it's time to dissolve the partnership. It could be someone that says, hey, this isn't working for me, I want to do something different. They want to move off and go somewhere else. Is there, something like that that's changed, is it's not what they thought it would be. And then, of course, it's important, everybody has to be in agreement as to, how this is going to be handled as far as dissolving this partnership. And that's where you get into, I've mentioned this before, I think, that maybe not in here, but in some of my other classes, that committees of 2 are usually not very effective. That's why it's good to have 3 people, so that you can have odd percentage, so that you can, vote 2 to 1 to get some work done. Because if you go, well, no, we have to be 100% unanimous, then nothing's going to get done in some cases. So that's important. Well, also, what about issues like death? What if somebody squandered money? What if somebody's stolen money from the partnership? What about a bankruptcy of one of the partners? These can affect the partnership adversely and call for dissolving of the partnership. Now, in the revised Uniform Partnership Act, because there is a harsh effect of the UPA, they've tried to come up with a way to soften the blow of that. Basically, that you don't have to dissolve the partnership every time one partner wants to leave. You could actually substitute another partner. There's other things you can do. You can have one partner buy out another partner. So they've tried to introduce more options to make it a little more feasible for the partnership to keep doing business. So if one partner wants out, that doesn't mean you've got to dissolve the partnership. Dissociation, that's spelled D-I-S-S-O-C-I-A-T-I-O-N. I'm going to put that up on here. What is dissociation? Well, dissociation is just where one partner withdraws from a partnership. Now, that doesn't mean that that the whole partnership has to dissolve. It's part of that RUPA aspect, that if one person just wants to leave, it can be a buyout. It can be a voluntary dissociation. It can be a wrongful dissociation, where if a person is stealing from the company, for example, somebody's stealing from the business, then it could be what we call a wrongful dissociation. So that's something where they've breached, they've done something to hurt the business, and they need to get out. So you're going to basically push them out of the partnership. Well, partners are partnerships formed by agreement, either oral or written. Partners have rights to manage the partnership. Partners share profits and losses according to the agreement. If there's no agreement, if there's nothing specifically said, then everything's split down the middle. Profits and losses split down the middle. If you have something specific where someone puts up more of the cash, then maybe they want more, so that should be in writing, 60-40. Unlimited personal liability, can't stress that enough. Something happens to the business, you're liable to get sued. Liability is joint and several. That means every partner is totally liable for any debt. So what that means is if, let's say, partner 1 incurs debt on behalf of the partnership, but partner 2 is still equally liable because partner 1 is partner 2's agent. So anything they agree on, they have the apparent authority to agree on it. So that can be, pretty bad. Partnership advantages and key features are inexpensive to form. They each owe the other person fiduciary duties. In other words, they have to be able to trust each other. Any withdrawal of a partner in UPA means dissolving the whole partnership, but under the RUPA, or Revised Unified Partnership Act, withdrawal does not require the dissolution of the partnership. It can actually just be what we call a dissociation, not a dissolution. Partnerships have to file an informational tax return. It is not a requirement that they pay taxes. Taxes are all paid by the partners personally. And so basically those are the main points that we wanted to cover. I hope you got something out of this. I hope it was interesting. And we'll see you next time with something more on business organizations. Thanks for watching. Bye now.